Hey there, Professor Fields here. Constitutional Law for Law Enforcement, AJ 170, El Camino College. This lesson is on inferences that can arise from a prior officer's prior experience. As a police officer, you have special expertise, and you can use that to spot training criminal activity. This expertise can be based on academy training. It can be based on experience on the job. It can be experienced um, in-service classes, things like that, specialized training. So you're allowed to use those observations, those filters, to view things and come up with an inference based on your training and experience, an inference that a regular citizen would not see. So let's talk about Ornelas v. the United States, 1996 case. In 1992, a Milwaukee sheriff's detective, uh, he observed a combination of behaviors, and based on his prior experience of 20 years of being a law enforcement officer, he ran a records check, and that created reasonable suspicion justifying an investigatory stop. And that is not the detective in the picture. That is, as some of you know from the movie Training Day. So the facts of the case. This incident attracted attention because he observed a California vehicle pull into a motel parking lot. California was a source state for drugs. Older model GM cars were popular with drug couriers, and Milwaukee was an unlikely winter vacation for a California visitor. And from being from California myself, Milwaukee is not a place I'd want to go during the winter, during the summer maybe. And for those of you fact checkers, that is not a period correct plate. That's a newer license plate. I just made that and put that in there to be funny. 420. So the detective ran a once check on the vehicle, actually ran a registration check on the vehicle, came back with the owner's name, ran the owner's name through Narcotics and Dangerous Drugs Information System, and to his surprise, okay, maybe not, the report came back that the owner was a heroin dealer from California. What a shock. So these facts, viewed in combination by an experienced detective, provided a particularized and objective basis for suspecting the owner's vehicle, and as such, they detained him for an investigation and subsequently arrested him and went to court, and that's why this became case law. He fought it on a Fourth Amendment, saying that there was enough uh, reasonable suspicion for detention. So over the years, law enforcement has developed a drug courier profile. Here's some of the characteristics, a few of the characteristics listed here. Youngsters, usually 20 to 30 years old. I say youngsters because I'm a middle-aged man. Travels to or from a major source city, stays only a short time. If they go on the plane, they buy a ticket right before, they pay cash for it. They don't carry very much luggage. They walk nervously, looking around. When TSA or whoever asks them about what they're doing for their trip, they give a false reason. Each one of those held separately is not reasonable suspicion. Those are behaviors of normal people when done separately. However, given the case of Sokolov, and I'm not sure if I'm pronouncing that correct, versus the U.S. in '89 case, this person was stopped in the airport by narcotics detectives for exhibiting the drug courier profile behaviors. They pay for tickets. I think it was a $1,200 ticket for $20 bills. Not not common. Traveled under an alias. You could do that back in the '80s. You can't do that today. Stayed in Miami for only 48 hours. Uh, this was a flight from Honolulu to Miami, and he stayed there only 48 hours. So 20-hour flight, and he stayed there only 48 hours. That's really suspicious. Appeared nervous. No luggage checked. All the way from Honolulu to Hawaii, and you don't check luggage. Things that make you go, So again, the Supreme Court ruled that while none of those things by themselves indicated any kind of wrongdoing, combination through the eyes of an experienced narcotic officer provided a reasonable basis for suspecting Sokolo of being in a drug career. Subsequently, he was searched and arrested. That's how we ended up being in court. So, as the court said, remember the judges are attorneys, and this is what they teach you in law school on day one. It depends. Just because you exhibit those characters doesn't mean you're a drug profiler. However, viewed from the eyes of an experienced detective, there was sufficient behavior to distinguish this person's behavior from that of the ordinary traveler. And that's the key word, the ordinary traveler, and allowed that detention. So there you have it, another lesson from El Camino College, Professor Mark Fields. Thank you for listening.